Good morning, everyone. I'm Teresa Hatton. I'm the CEO of the Massachusetts Association of Realtors. Thank you for being with us this morning. Not really March going out like a lamb today. It's pretty darn cold out there, but we're happy to kick off the first in our quarterly broker programs for 2022 on this nice, brisk, cold March morning. I'd like to thank our panelists and introduce them this morning as well. First, starting with Jay Chaisson. Jay is Vice President and General Counsel for Jack Conway and Company and a Director of Conway Commercial, and has been with the company for 27 years. He's an attorney and also a licensed real estate broker, and he teaches the real estate sales and brokerage course as well. He's been involved in the development of construction management and sales and leasing of residential and commercial real estate. And Jay, thanks for joining us this morning. Bob McCauley has been Vice President and New England Regional Counsel for Coldwell Banker Realty for the last 19 or so years. For 9 years before that, he was General Counsel for the DeWolf Companies, which was a publicly traded company with a real estate brokerage subsidiary, mortgage company subsidiary, and insurance agent subsidiary. Bob, thanks for being here. Always a pleasure. Bob and I had the pleasure of working together with each other through some of the issues that we'll be talking about this morning. So thanks for joining us.
Glad to be here.
And Richard Sullivan is formerly the in-house counsel for the Greater Boston Association of Realtors and the Greater Boston Real Estate Board from 1997 through 2002. He was in private practice for 17 years before becoming general counsel for Gibson, Sotheby's International Realty. His legal career has been focused on real estate and real estate brokerage matters. Richard, thanks for joining us this morning. Catherine Taylor, our very own at the Massachusetts Association of Realtors, has been with us since 2017 and serves as our Associate Counsel. And Catherine manages the legal hotline. A number of the hot topics coming up this morning, she hears about on a daily basis through the calls. So Catherine, thanks so much for being here. She also works with our education and making sure that we have the right tools in place for our members. And Justin, our General Counsel, Justin Davidson, will be our MC for this morning. Justin is in charge of our government affairs, advocacy, and legal matters here at the Massachusetts Association of Realtors. So without further ado, Justin, I hand it over to you.
Thank you, Teresa, and thank you to our distinguished panelists for joining us today. We have, just to let everybody know, we all got together a few days ago and started listing off some topics that we wanted to cover. And soon we were on to about page 3 of topics. So needless to say, there is a lot that everyone wants to talk about. So we will jump right into it after I give everybody's favorite disclaimer that nothing that is said here is any of the attorneys providing legal advice to you all. This is just legal information to help educate you and your agents. So with that, we will jump right into where we left off last year. We all got together. We were thinking that we were done with COVID policies. Here we are a year later. Some of those COVID policies are still in place. Some are not. And when I talk about policies, I'm talking about brokerage policies. So let's talk about, are you guys still seeing our open houses back? Are people taking anything that they implemented during COVID and keeping it as we hopefully move out of the COVID pandemic? Richard, do you want to kick us off?
Sure. Open houses are back with zest. To what degree they went away, before it was you were doing showing time, 15-minute showings, and our agents were there at 10 a.m. and there at 8 p.m. as the truckload of people walked through 15 minutes at a time. Now we're back to a more regular hour, 2-hour schedule. It's really back. We periodically get complaints, and usually it's a tenant in place who just doesn't want the property to sell, who is the one raising the COVID concerns. But other than that, sellers aren't nervous about it. We're going full bore.
Yeah, I excuse me. Yeah, I'd agree with Richard on that as well. The open houses are back with a vengeance, as you might say. But we're really not seeing any COVID concerns. The agents customer buyers, sellers. So far that sort of has petered out to a great extent. I do echo what he also said, however, about tenant showings and things of that nature. Sometimes that can present itself, but we do a fair amount in the city, like you do, Richard, and you too, Bob. So we don't, but we don't even see that too often. So.
Yeah, we had developed about 6 or 7 forms, COVID-related forms, temporarily off market, withdrawal, eviction moratorium, property showing advisory for the buyer, property showing advisory for the seller, sight unseen disclosure, and those are still available. But you know, I at this point I doubt that any of them are really being used. It seems like things are pretty much back to normal. We're not seeing. I think all of the restrictions that were in effect from town to town that apply to offices have been lifted as well. So we're seeing, you know, things pretty much back to the way they were, you know, before COVID really hit.
All
To
right.
echo what
Yeah.
Richard said, what I'm hearing mostly through the legal hotline with regard to COVID policies is related to those landlord-tenant situations where tenants are making requests that prospective buyers be fully vaccinated or, you know, have enhanced protocols. But I'm not getting a lot of questions about open houses and things of that nature. It's mostly in the rental scheme.
Yeah, and we are still seeing some in that as well in the rental, also where sellers are the agent to screen prospective buyers or prospective tenants for vaccinations, and we have resisted doing that. We don't want to be the vaccination police. We don't want to expose the seller or the landlord or the agent to claims that, you know, we may have excluded somebody in a protected class. So we have resisted those requests, you know, from sellers or landlords, you know, for the agent to basically, you know, screen prospective tenants or purchasers for that purpose.
Same here.
Same here.
All right. Well, thank you for that. And I think, you know, we're heading into Fair Housing Month. So let's talk about one of our top issues, and that is fair housing. In the past, we've had a lot of discussions about the so-called buyer love letters. Are you still seeing those in the marketplace? How are you talking to your agents about them? And I imagine that's a different conversation that you're having with a listing agent versus your buyer agents. Bob, what are you seeing with the love letters?
Yeah, we're still seeing them. We're definitely cautioning agents on the list side against using them and having a discussion with the seller in advance about the risks associated with that, and because of the risk that a love letter or photographs that might be included with a love letter might reveal some protected class characteristics of a buyer. And if that particular buyer is rejected by a seller, it could give rise to a claim for discrimination. So we certainly are cautioning people against doing that. On the buy side, you know, we're still seeing some buyers that may be insisting on using love letters. And, you know, ultimately it's their prerogative. And the risk is really on the list side and the seller side, not so much on the buy side. So we may still see buyers wanting to do that. You know, we've seen some situations where listing agents have told buyers agents it's illegal for you to do this. It's not really illegal for the buyers to do that, but it creates exposure on behalf of the seller and the listing agent if love letters are used, and then, you know, a seller rejects a buyer, and the seller is now aware of protected class characteristics. So we're discouraging, certainly strongly discouraging agents from, you know, having that discussion with the seller, discourage them from accepting or even receiving, you know, if the listing agent gets them, we're not going to transmit them to the seller. So that's kind of the advice that we are giving out.
We did an addendum for our listing agreement that advises the seller of the danger of the fair housing claim and really kind of the business nature of this. So our agents are saying we will not present them. I get a lot of feedback because I've been beating this drum for a while, but there are agents now who are saying straight in the MLS outside of my company, do not present love letters. So I think that's a real positive for the industry. And because I bang this drum periodically, people who are listing agents send me these love letters that are professionally printed with photographs. And they're like, hey, Richard, we tossed this in the trash, but we wanted you to see it first. So they know how to get me. So
It's an ongoing process of education. We raise the issue with our listing agents and buyer agents frequently. Talk about the dangers of it, particularly to the seller, who clearly may not be fully aware of any type of, potential threat that's out there. We caution strongly against the, sometimes you can't avoid them, as Bob said, but we caution strongly against the placement of a photograph in the letter. And I think it's just a matter of the market that we're in, and training and education and time will take care of a lot of it, particularly with training. And I can't go ahead. I know Richard and I and Bob talked, a few times on it, both this time last year, maybe a little later. And it sort of revolved around our conversation revolved around some of the craziness in some of these love letters, which was bordering on creepy in some of them. We can hopefully that will change as we educate and we help educate our agents going forward. We think it will.
Yeah, and Catherine, can you talk about MAR's forms? And then when you get these calls on the hotline, how are you talking to agents about how to handle love letters? Who's making that decision not to present love letters?
Yeah, absolutely. So this is definitely an issue that's been, at the top of the questions I receive on the hotline for probably about a year or so now at this point. And we have added a couple of forms to our forms library for our members to use in your business practice. Our exclusive right to sell does have a line in it saying that the seller and the agent are going to adhere to all fair housing rules, but that's easy to gloss over that one sentence and what exactly that means. So now we have two standalone forms particular to the issue of love letters. We have one that's a seller instruction regarding buyer letters, and one that's called fair housing considerations for buyers. And it's really that educational tool that says, this is what love letters are. This is how they're being used in the marketplace. This is why they potentially pose an issue to you and your client. They're optional forms. They don't have to be used, but particularly the seller form, by signing it, that seller is then instructing their agent to put that instruction in the MLS that those love letters are not being passed along to the seller because of the potential exposure. So it serves both as a liability protection as well as an educational tool there. But it's important to highlight, particularly in these situations where that decision shouldn't be coming from the agent or a broker. It can't be saying, no, we can't do this. It's educating them and letting the client make an educated decision and say, yes, I do want you to withhold them, or no, please pass them along and show them to me. And, I'll assume that risk, but it really needs to be a decision and an instruction coming from your client as opposed to a broker or agent policy.
Thank you.
Very good.
And love letters are just, one small component of fair housing law that I think we are all focused on. What areas are you most concerned with when it comes to fair housing? Richard, what keeps you up at night in the fair housing world?
Well, one of the things right now we're dealing with a lot more Section 8, and part of the reason is because Section 8 has really adjusted so that their fair market rents are truly fair market rent, and they go by zip code, town to town. So we're getting more and more calls on Section 8, and we want to make sure we're educating the people. We actually had VASH with the Veterans Assisted Housing come in and talk to our agents. We had Boston Fair Housing talk to our agents about handling the Section 8 as well. But we're bumping into issues where we've had people saying you will pay above that as long as you don't disclose. And obviously we can't be party to that type of thing. So we're kind of making sure we're walking a thin out line, and then they throw us the curveball. So that's kind of what's scaring me.
All right, Jay, Bob, anything that comes to mind, anything you're doing now to, help educate your agents in the fair housing sphere?
One other area that I would mention too is no pet policies and service animals and support animals, that would be permitted under Fair Housing Act. If a prospective tenant requests a reasonable accommodation for a service animal or a support animal, and that would trump no pet policies that might be in place by a condo association or an individual seller. So, something else I think, to be aware of, that you can't just unilaterally enforce a no pet policy if somebody is requesting a reasonable accommodation for a support animal or a service animal. So
the recent, the recent HUD updates on service animals are very, very helpful to landlords to clarify, how you would define a service or a support animal.
Yep.
The proof, so to speak, of, from the prospective tenant as to why they need one. Specifically the, some documentation from a loosely defined health professional. Let's leave it at that, because I'm not exactly certain myself what qualifies and what doesn't. But it's one of those things where you sort of know it when you see it. Those have been very helpful to our agents in providing guidance to their landlord clients, which I might say, I was talking to an agent about this just a couple of days ago regarding the same question. And I'm hearing from many of my tenant representatives and landlord representatives that they're seeing that fewer and fewer times, that no pet policy, for reasons I have no idea, other than perhaps virtually everyone has a pet these days. But needless to say, it's a matter of training again, and training landlords sometimes more than our agents. I think our agents are ahead of the curve on some of this thing, more than their clients are.
And Justin, I saw a request for the HUD policy. I or Jay or Richard can send that to you afterwards, and you can share that as you feel appropriate.
Yeah, we'll have that up on the website. Thank you.
Okay.
In the
Share it in the chat as
Massachusetts,
well.
the Massachusetts website on service animals and emotional support animals is a good link to have. And what we will do is send it to the agent so they can send it to the landlord. But what we're telling our agents, the landlord makes the decision, the condo association makes the decision. We don't make that decision. But I think between the mass.gov and the HUD, it gives great guidance.
Richard, you just took the words out of my mouth. This is probably a question I get at least once a week from agents. And I say, I'm happy to give you background information, but please don't be telling your clients how to make the determination, because that's legal advice. And also please, make sure that they're working with their own legal counsel to make their own determination. You don't want to be placing yourself in a position where you're making that determination of whether it does or does not qualify as an assistance animal. But it's a big topic out there. Lots of questions.
All right, we're going to switch gears a little bit, and it is tax season, so we will cover one of our favorite topics, and that's paying unlicensed LLCs. It's something that comes up right around this time every year. Catherine, you hear about it on the hotline probably before anybody else. So it's agents that are talking to their broker and saying, well, I want you to pay this LLC because this is what was recommended to me by my accountant. Catherine, how are you talking to agents on the hotline about that?
So usually it's the brokers that call, not the agents. And unfortunately, a lot of times the brokers call me and say, my agent set up an LLC, can I pay it? And I say, well, unfortunately, probably not if they're a salesperson, because that LLC isn't appropriately licensed. Only somebody who holds a broker's license can license a corporation, an LLC. So they've taken the advice of their accountant and gone ahead and set up this LLC. But unfortunately, a broker can't pay that entity if it's not licensed, because then they're paying an unlicensed individual. But yeah, always see a huge uptick in this question during tax season. I probably get, oh geez, in March, maybe 2 or 3 calls a week on this question.
Every time this year. This time every year. Yeah.
And it can be tricky because there is no clear law that just says you can't do this. You have to sort of read the entirety of the real estate law to understand how that happens. So, you know, an LLC needs to be licensed in the state to receive compensation. So that's where this stems from. Richard, Bob, how's it going with your agents and brokers?
Well, in going to the totality of the licensing law, one of the other things is that, you know, a salesperson can only work for one broker. So even if you have the team that is made up of a husband and wife, and one is a broker and one's a salesperson, so they set up the LLC and they get the LLC licensed and they come to you and say, well, now you can pay us. Well, the salesperson, who are they working for? Are they working for the LLC or are they working for me? And if they're working for both, they've violated the licensing law. So it's very restrictive when you read the whole thing. But, you know, this is the time when people do their taxes and their accountant offers to set up their LLC or their corporation for them, and they pay all this cost, and then they come to us and we have to say no.
Yeah,
It hurts when they set up the LLC or the corporation in advance on the advice of their accountant, and let it come to us and say, sorry, we can't do that in most cases.
Yeah, and we recently had an individual agent who had set up an LLC, audited. The DPL does random audits, and they audited this particular agent, the LLC that they had, and they have a form that they go through that they would use for, you know, to audit any brokerage, and they use the same form to audit the agent's LLC. I don't know if Catherine, you can pick that up or not, but it goes through the requirements on this form that applies to LLCs. And you can see right here in the kind of the middle of the form, if registered as an LLP or LLC, insurance must be maintained as required by, and those are the statutes that they're referencing. So they're expecting the agent to have insurance, errors and omissions insurance on the LLC. And in this particular case, the agent looked into errors and insurance coverage, and it was going to be $1,800 a year, you know, for as the premium. In addition to that, if you, there is also a requirement for a bond. I don't see it on this page, but it might be on the next one. Oh, at the bottom of there. Yeah, proof of an appropriate bond for the broker. So they're expecting a bond to be in place as well for the LLC. The other thing, the other point to make, I think, about the LLCs is that, you know, some agents, the accountants may advise them to, oh, you can just pay your team members through the LLC. Well, that's a problem as well. They have to be paid by the broker with whom they're affiliated. So the commission should flow exclusively from the broker with whom they're affiliated. They can't be the interim pass through for commissions to their team members. So that's the other thing that, you know, I think is important to key in on. So anyway, just wanted to make people aware that that is the actual form that the DPL uses to audit brokers as well as LLCs that an agent might create.
And I think an important point of clarification comes to hit on, I think I saw it come through the chat, is that if you are a broker working under another broker, this limitation doesn't apply to you, because it's only those people who hold a salesperson's license that are unable to establish an LLC to receive their commissions. If you're a broker, you may do so because there are not the same affiliation limitation requirements for somebody holding a broker's license.
One of the concerns I've had with team leaders paying team members themselves directly is, and I'm no expert in this, so I want to qualify what I'm saying, is process of doing that. I think they raise or issues of wage and hour concerns can come to light, and workers' compensation, insurance, et cetera. So, you know, taxes, tax withholdings, all of those questions come to mind, insurance, liability insurance. It's a tangent off of what we're talking about, but, you know, for a reaction, there's always a reaction. And I think that's a concern that comes up. Although honestly, I can't speak to it too well, but it's something that's, we need to be concerned about it. That's what's happening.
All right, so you sort of just led us right into another topic, and one that I'm sure could take up an entire morning in and of itself. That is teams. Massachusetts still doesn't have any laws specific to teams on the books. So how do you advise agents in your office about affiliating as teams? And I shouldn't even use the word affiliating as teams, but grouping themselves together as teams. What do they need to be worried about when it comes to their marketing? And Catherine, do you want to kick us off with sort of some of the top concerns that you see?
Yeah, absolutely. So one of the big issues I see with teams is advertising. There's not clear regulations as far as how a team has to advertise. Really, what our licensing law and our code of ethics states is that it has to identify the broker with whom you're affiliated, as well as having it in a readily apparent manner. So what readily apparent is a little bit open to interpretation. In some places you see it's more obvious than others. In some places it's pretty obvious that where the brokerage name is itty bitty and you can barely read it, probably doesn't satisfy that requirement. I know a lot of brokers have within their offices their own policies with regard to advertising, whether it's ratios or providing specific templates to make sure that that broker name appears readily apparent to a consumer. But I would say that's one of the biggest issues. Now, thankfully, we've gotten a little bit of guidance from the Board of Registration with the FAQ they put out last year that does say, here are some good guidance as far as what team names can be used, what shouldn't be used, what words should be avoided. It really comes down to consumer protection. How are you portraying yourself to the consumer? If your name sounds like a brokerage, it's probably not going to satisfy that requirement. So, group, team, things like that are okay, but you don't want to have anything that suggests that you're a standalone entity.
All right, so if we had the Sullivan Chaisson group, it would be one thing, but Sullivan Chaisson Realty would be an entirely different thing. Is that what you're all seeing in your with your agents as well?
Yeah, absolutely.
Mm-hmm.
And the guidance she mentioned is great. It really is. And that's something you should have on your desktop to give to your agents when they say, we want to form a team. Here's the guidance from the Commonwealth. Make sure you comply with this.
Yeah,
So
I agree.
I'm sure that can get posted on, a link can get posted in the comments.
Yeah, you'll get no pushback. It tells you what words you can use, what you can't. And it's very clear.
Okay, we kicked this off by talking about how open houses were back, busier than ever. After the open house, oftentimes, at least historically, would come an offer acceptance and an inspection period. Inspections have changed a little bit. One, are you seeing a lot of buyers waiving the home inspection? And two, how are you talking to your agents about the risks involved when a buyer wants to waive a home inspection? Jay, you want to kick us off?
Anecdotally, we're not seeing it as much as we did last year. I've talked to some closing attorneys, and they're telling me that they're seeing home inspection contingencies with a certain amount of frequency. Just working with watching one of my daughters purchase a house to try to get a home inspector, and I encouraged her to get a home inspection. Took her a while to schedule one, so they were busy, which I take as a good sign. We're very cautious about it, Justin, very, very cautious. You and I spoke when the group of us spoke the other day, we were talking about the latest ramifications that still come down the road, about issues with with buyers having waived the home inspection to be competitive. Certainly, and hopefully not at the recommendation of their buyer's agents. So those concerns still exist. Truthfully, we haven't seen any yet as far as, comebacks from the buyer who discovered a problem, discovered an issue. We've had a few calls, about people who had discovered things subsequent to closing on the house. But nothing has really come of them to any great degree. But it's something we're concerned about as time goes on. And one of the things that we do caution, one of the things I caution our agents to do is, other than the obvious things that the other gentleman, everyone and Catherine, everybody will talk about, that is just, making sure the buyers understand the risks by waiving the home inspection and, and documenting that properly, making sure that idea doesn't originate with that buyer's agent. Or heaven forbid, the seller suggesting it, the listing agent. But no, we're very careful. We're very, very, very cautious about it. We encourage, and we suggest to our agents that when they're in a situation like that, when the buyer is, these buyers are coming tuned to waiving the home inspection. We suggest to them, if they're in that type of a situation, that they review all of their MLS data. Make sure the information is accurate. A couple of times that has been said to me over the years in previous markets like this, where the buyer says, well, your listing did say X, Y, and Z, and that wasn't the case. That's why I didn't do a home inspection. Whether they have a point or not, I'm not sure, but it's something we can avoid just by making sure, go back and take a look at that data again. Make sure it's accurate.
We're seeing quite a bit of buyers, with the lack of inventory, number one, and still a pent-up demand from buyers. We're still seeing buyers who feel that they have lost out on 10 other offers on other properties and feel that they're compelled to do something to give them an edge, over other buyers, and they feel compelled to do it. So we are seeing, situations where buyers are waiving home inspections. And in some cases, agents may be influencing buyers to do that, because of the market the way it is right now. We have a form that we call it a home inspection advisory, where we are advising buyers not to waive home inspection, and we advise them of the risks associated with doing so. Ultimately, it is the buyer's decision, and we'll respect what their ultimate decision is. But it's not what we want to make it clear that we're not advising them to do that, and if they do so, they are assuming the risk associated with unknown problems or defects in the property that may show up afterwards that they're not aware of. So we are very aware of the risk associated with that, and we do caution buyers about the risks associated with that.
And it's this.
Go ahead, Richard. Sorry.
Same here. We have a waiver of home inspection form that is an addendum to the offer that just says, we understand, we've read the Facts for Consumers brochure, we are doing this. Our buyer's agent has recommended we get a home inspection. But as Bob said, when the buyer goes in on the first instance and they're having every contingency under the sun, and along about the 10th time they get rejected, they start saying, I need to scale back. And that's the conversation you have with them. And the conversation as a buyer's agent is, something will go wrong, and how are you going to pay for it? So you have to go in with the expectation that you're going to be putting your hand in your pocket to fix these things. And I saw some of the comments about the listing agents pushing it. And, I wouldn't want my agents telling people, we want your buyer to waive their home inspection. But if it's a multiple bid situation where, the seller has empowered you to give you certain information, and you say, we have 15 offers and the top 5 have waived their contingencies, you're reporting back without disclosing a term. And as long as the seller told you that, I'm fine with it.
You know, the other issue that we're seeing is language that's being inserted in agreements that basically say inspection for information purposes only. And what is the meaning of that? And agents still seem to think that, you know, you can terminate the agreement if you just put for information purposes only. And, you know, if it's just for information purposes and there's no language that's attached to that that gives the buyer the right to terminate, then I don't see how you have a right to terminate and get your money back. You know, your deposit would be at risk under those circumstances. But yeah, we're seeing a lot of that as well, you know.
Well, that's one of the things we joke about is that, you know, we have 5 attorneys on this panel and we could have 5 different interpretations of what inspection for informational purposes only means. Catherine, you were just about to speak, sorry.
Yeah, no, it's okay. I was just going to say MAR also has a waiver of inspection form. In our forms library, it essentially says the same thing, that it's not the agent advising the client to waive their home inspection. They've knowingly made the decision to waive it on their own and they're assuming the risk thereof of doing that. So that's available for all of our members to use. I've been hearing less about this lately, though, through the hotline. So I think it might be cooling down a little bit, particularly with the information only inspections. That was like blowing up the hotline for a little while ago. And now I'm not hearing as much about it. So I think we've done a good job educating our members that that phrase is a little bit nonsense and doesn't really accomplish what you're hoping it to accomplish. So hopefully people have worked with their attorneys to craft a little bit better language in those situations, but I'm hearing less of that.
I think, Catherine, is it's the calm before the storm, because we're not hearing much about it either. And it's probably, if I had one topic that I get the most calls on is, what does informational purposes mean only? You know, and it was like, you know, I didn't invent this, you tell me, you know, it's kind of one of those funny things. But you're right, we get 5 lawyers on the panel here and have 5 different interpretations. So to Bob's point, yeah, make, you know, the language got to be in there. Make, you know, have the language properly drafted. If not, sometimes I just suggest to them, you know, talk to, you know, with the other agent involved in the transaction, have a discussion with what does it mean to, let's all come to an agreement as to what it means. Okay. So that there's no confusion, address the issue, put it on the table. Okay, this is what it means. You know, if I bought it back out, do I get my $1,000, $500 deposit back, whatever the case might be, and including right up to if it's after the purchase and sale agreement we had one the other day, which is it's a little touchier at that point, right, Richard? So yeah, it's we're seeing less of it. Hopefully, people have come to some sort of conclusion what that means. It remains to be seen.
All right, Richard, you looked like you were about to jump in with something.
Well, no, I saw a comment about, you know, they saying, well, you don't have a right to a home inspection, but if you're a buyer, you have a right to fashion your offer however you want to have it. So I'm not saying it is a legal or constitutional right to include it. I'm saying if I'm writing my offer, I can write it, you know, with the contingencies I choose. The seller has no legal obligation to accept my offer. So, you know, I saw that, and it's like, just to clarify that point. But a lot of the times too, we get the waiver of home inspection, and then prior to P&S, the buyer wants that just for informational purposes only. And we always tell them, great, once the P&S is signed and the deposit goes hard, you can have your informational inspection, and the seller's attorney will be clear that if you don't buy, you don't have the contingency and you'll lose that money. And that's where we get pushback. But we push back.
All right. So one of the other big contingencies that is rather common is the financing contingency. Are you seeing waivers of that? And again, how are you working with your agents to make sure that their clients are protected? Or is that a common waiver at this point? Bob, you want to go first?
Yeah, I'm not seeing too much of that that's been brought to my attention. One side issue that has come up in the context of escalation clauses is how that impacts the financing contingency, because if somebody has put an escalation clause in the agreement and is willing to pay $50,000 over the next highest offer, the buyer and the buyer's agent should be aware of the impact that that's going to have on the financing contingency, and whether or not the buyer is going to have the financial resources to make up any difference if the price is escalated, or whether they're going to have to request a higher mortgage contingency, and make sure that that's taken into consideration when the when the agreement is ultimately signed.
All right, and before we get really deep into escalation clauses, because I think that's a topic that we'll want to spend at least a few minutes on, sticking with financing for a moment here, are you seeing people come in and saying, all right, I'm going to do cash, but then they're requesting an appraisal, and sort of how's that working in the industry right now?
I've seen it a few times, but not a lot, where it comes in as a cash transaction. And then, the buyer wishes to pursue a mortgage. It's been some of those, there's not been a lot of them, truthfully, Justin. And on a couple of occasions, the buyer has been able to say, I'm going to try to get a mortgage. I hope you'll accommodate me with respect to a mortgage, an appraisal. But if push comes to shove, I'll be there at closing with cash if I have to. So I've seen a couple of those, but not too often.
Yeah, and I think it goes to caution in using your terms, because if you're the buyer's agent and you present it as a cash offer, as opposed to we're not requesting a mortgage contingency, those are two different things. And if you're a listing broker and they're saying cash, it should be asking for proof of funds anyway. But we had situations during COVID where sellers took the cash offer and the buyer came back and said, well, we're getting financing. And the seller said, absolutely not. You said it was a cash offer. I was freaked out by all these people coming in my home, and I don't want an appraiser coming in. And I'm not going to agree to TRID language, and I'm not going to agree to any of this. And, be clear. If it's, we're not seeking a finance contingency, don't call it a cash offer.
Mm-hmm.
That's a good point. Catherine, have you heard of anybody changing the type of loan?
Yeah, so I've got a couple calls on it. I wouldn't say it's a trend by any means, but certainly I've gotten a number of calls where people have included a financing contingency and perhaps specified that they're getting a conventional loan, and then they decide to switch to VA, for example, which have very different requirements. And they're wondering what their obligations are to accommodate that buyer's request to switch the type of financing. And I always say, well, it depends on what your contract says. If it specifies the type of loan, well, then you might have to agree if you're changing the type of loan. But if it just says that the buyer is obtaining financing, then it's a little bit more open. So it's important to be clear in your contract language and understand what that language means that you're including.
All right.
We see that too. We've seen that, a rash of them in the last couple of months, actually. Catherine, I'm getting these calls when my buyer came in as, the buyer was pitched as a conventional mortgage buyer, pre-approved to that, and then is switching to FHA. The ones I've gotten more FHA. And again, the questions come up, what are the seller's obligations, etc. I did the same thing you suggested, Catherine, for into the contract. And to get you to thinking that maybe those terms we sort of take as automatics, financing contingency, et cetera, like the home inspection contingency, we have to maybe delve a little deeper into, okay, let's define what you refer to as conventional and et cetera, and some of the obligations parties will have. Ultimately, the contract prevails, and you can't, unring the bell. The contract is what it is. So that doesn't always sit well. Because you get a buyer, you're into it, 2 or 3 weeks, and the seller's looking at you and saying, as a listing agent, well, you told me it was conventional finance. Now I got to paint my stair risers, something to that extent. But leads to a conversation that in the future maybe be a little more, dig a little deeper behind that.
Right. With one point I would point out is that you may see some people say, well, I'm switching to VA financing because every time I put in an offer with VA, I got shot down and now my offer gets accepted. And you're telling me that you would not have accepted my offer if I told you I was a veteran. And that's a fair housing issue. So it is a problem with that, particularly with veteran VA housing, they are identifying themselves as a member of a protected class. So you're walking a tightrope. And if they do say, so would you have rejected me if I put this front and center? The sellers better have a law degree to answer that question.
Justin, one other kind of side issue, it's not necessarily related to waiver of financing contingency, but it does relate to financing contingencies that are in place, relates to if the property doesn't appraise out, and how is that going to be handled, and trying to anticipate whether this is going to be is the buyer going to assume that risk? Is the seller going to assume that risk? Is there going to be some kind of sharing? Does the buyer have the financial resources? If the loan is not approved for the amount that he or she is requesting, and so they're the lender is only going to approve a lesser amount, how is that going to be handled? So those are kind of side issues that I think can arise, especially in this market, with the prices appreciating the way they are, and people making offers above asking, whether property is going to appraise out, and how's that going to be handled if it doesn't appraise out.
Great.
Thank you. All right, Bob, you started to bring us into escalation clauses a moment ago. I figure it is something we should all touch on. And I think I see some smiles because escalation clauses can, I think, drive a lot of people a little crazy. Richard, how are you working with your agents, advising them, talking to them about working with sellers on how they might handle escalation clauses if they do come in?
Yeah, I mean, to a certain degree, it's usually not the seller who brings it up. It's going to be brought up with the buyer. So the listing agent will bring it up to the seller saying, we expect multiple bids, therefore we expect that we'll probably get the escalation clause, and you have the conversation with them. And I think, what the listing brokers tell them is, or listing agents tell them, is based on their experience. So when I'm talking to buyer's agents, I always say, get on the phone with the listing agent and find out what their opinion is of them. And if they tell you, I hate them, do not use one, because that listing agent is going to be saying to the seller, this is not a good offer. Sometimes they like them and so understand what they want. I'm old fashioned. I like the old system of put in kind of your best and highest and either win or lose. But a lot of the times the conversation with the buyer's agent is, just what we're talking about. Before you start getting carried away with this bid, what can you afford? What can you afford if something goes wrong? What will your mortgage, kind of a mortgage, do you need in dollar amounts? So before you start bidding yourself up and get into trouble, maybe it's better for the buyer to go in clean and not have those problems and just do what they can do. So I've never been a fan of the escalation clause.
Yeah, Jay,
you certainly. Yeah. Oh, sorry, Justin.
No, Catherine, go ahead.
I was gonna say, I think there are definitely pros and cons. And to Richard's point, I think people feel very strongly about them. I've never talked to anyone who's ambivalent about escalation clauses. Yeah. It's either I love them or I hate them. And to Richard's point, you want to be cognizant of who you're dealing with for a smooth transaction and what their feelings may or may not be on it. But it's important to remember that it's always got to come from your client's instruction of whether you're not going to accept them, for example, because we've seen a lot of things as far as instructions being placed in the MLS, escalation clauses will not be accepted. And then the question is, well, can they do that? And the answer is, well, maybe. I don't have enough information to answer that question. I don't know the conversation they had with their client as to whether the client said, nope, don't want to deal with that. Just come in clean, tell me what you want? Or was that really directed by the agent? So be careful to make sure that you are having that conversation with your clients, that they understand what they are and how they work before placing instructions like that in the MLS.
No one's ambivalent about these escalation clauses. No one. You either love them or you hate them. And I agree with that, Catherine, in the sense that I think, you talk to maybe perhaps a listing agent, she says, nope, the seller does not want escalation clauses. Looking at the totality of the situation, seller probably doesn't get a clue what escalation clause is at that point, but she clearly doesn't want one. Right. So, it does require, I think, a conversation with the client, but it's, the listing agent's bias is going to come through on that. And like you said, there's very little middle ground on the opinions when it comes to those things. And,
well, sooner or later, it's got to be quantified. I mean, you could have 5 escalation, 5 offers with escalation clauses. Well, how much is each one offering? You don't know that until they actually, come in with a hard number. So, we tend to discourage them too, but ultimately it's, the seller's decision, as Catherine was alluding to.
And that's the thing that Bob just mentioned. People think, well, if I put in the escalation clause as if it's a one-on-one relationship, and we get 10, 15 offers, and you go back and say best and highest, and now we have 10, 15 escalation clauses, and no one knows what people are asking or offering, and if they can afford it.
Yeah, that's a good point, Richard. Jay, we chatted about this briefly. That it's easy to think about it when it's 1-to-1, but when you have potentially 5 escalation clauses that are all needing to be layered together, it can be easy for an agent to get in over their head in that situation.
Way in over their head. I've seen them now, see them occasionally, where there's different layers of qualifiers on those escalation clauses. And you really almost have to stop and chart it out to see exactly what they're offering. You have caps, and then you talk about exceeding the caps, but what happens if the appraisal doesn't come in and the cap is low? I've had experienced agents send me these, listing agents send me these offers. They couldn't, they couldn't make sense of it in some cases.
And we've talked
on 2
about this.
occasions, neither could I.
Sorry, Jim. And we've talked about this before, but from the buyer's perspective and the buyer agent's perspective, if you put a cap in there, as to what the maximum amount that a buyer is willing to pay, you're pretty much tipping the buyer's hand, what their highest offer is. And the seller could just go back, even if there's no other offers on the table, the seller can just go back and counter at that amount. That's just something, to be aware of as well, that, you could be compromising the buyer's bargaining position by putting the cap in there.
That's happened several times.
Right. And then if you have no cap, we had one recently where, the buyer came in like 20, 30,000 below the asking price, and no cap, $2,000 more than anyone else. And the buyer's agent saying to the listing agent, but I won, I was $2,000 more than anyone else. And it was like, you came in low, no one believes you. You got to write this to actually, you knew how busy this open house and how many showings there were. So if you're going to do it, if you're going to say $2,000 more, you might as well say $105 more,
Justin, I just saw a comment, always include a cap. Well, the buyer's not going to be committed to an amount unless it's countersigned by the seller and there is a specific amount that's been agreed to. So it's not like, that they would be, without a cap, that they would be committed to an amount in there. If it just says $1,000 over highest asking, it's not like the seller can sign that and have the buyer bound by an agreement that doesn't state an amount in there. They would still have to come to terms on a specific amount.
Justin, we've seen recently some offers come in with, buyers offering to pay certain expenses of the seller, to stay on the property for a period of time. those, and then sometimes we're seeing those in place of escalation clauses. Those take sometimes a little more guidance with the agent because, essentially agreeing to 6, 7, 8 months of free, use and occupancy. And, I talked to the agent, explain, well, at that point, you really, your buyer is becoming the landlord, and a whole other plethora of issues present themselves. Random questions. Who's going to pay the utilities? Pay the insurance? It's going to go into the winter. Who's going to be handling snow and snow removal, etc., like that. And you let paint to the property. Oh, didn't think of that. So that's something that you got to really look at. Use and occupancies. We have our own use and occupancy agreements, and they're great for the holiday weekends and 3 or 4 days, but 6, 7, 8 months.
Well, and now it's an investor mortgage for that buyer because they're not moving in. So it changes the rate they're going to pay, and that's why people always say rent back, and we always say use and occupancy. No rent, never say rent.
Yeah. The takeaway is it requires some thinking and planning. And I strongly recommend that the buyer's attorney gets involved in this early on, as with the seller's attorney, even maybe in conjunction with the offer, to lay out some of the parameters here as to what's what is a 7 or 8 month use and occupancy.
Great points there. And we are just about out of time. We have tried to cover a lot of the questions that came in throughout our discussion here. So thank you everybody who sent questions in, but we can't close this out without talking about cybersecurity and what needs to be done to make sure that agents and clients are being protected in this day and age. So anybody want to jump on that one first?
I'll take that one. So I'll just say that with the pandemic and so much more business moving to the virtual world, internet and cybercrime is so much higher than it ever has been historically. So it is critically important to take steps and educate your clients about wire fraud and cybersecurity, and be very careful about what information you are transmitting electronically. We do have our wire fraud advisory in our forms library, which I would strongly encourage you to use as a catalyst to that conversation with your clients, and remind them frequently as the transaction progresses. And you're starting to talk about wiring instructions and things, just say, hey, remember this form we signed at the beginning? It's still relevant, still be extra careful. Pick up the phone and call to verify that information.
I agree.
Yeah, and we've had situations where former clients have called an agent like 3 or 6 months after they bought their house, and they say, I was going to buy a car and I got these change of wire instructions email, and I thought about that form that you kept telling me about in wire fraud, and it turns out it was a spoof email, and had I sent $30,000 or $40,000, that would have been gone. So you really, your agents really need to stress this to people, because it's out there and it's real and it's happening every day.
But it's also entering into the public conversation, and more over time, more and more people are aware of it. And they'll think for a moment, they'll reach out, they'll ask a question. So fortunately, I think that's helped, the public awareness of that whole concern, of this whole concern. It's good. But yeah, you're right. You've got to be constantly vigilant, because these things happen. They happen fast, and they usually happen, the ones we've seen as well, without really any forethought by the person sending initiating the wire, sending the wire, whatever the case might be. Yep.
All right. Well, I want to say thank you to all of our attorneys for joining us. And with that, Teresa, I will turn it back over to you.
All right. Well, thank you everybody for attending this morning. As a reminder, this is being recorded, so you are welcome to use this and any other of our archived webinars during your sales meetings. Dawn mentioned something about Pearl Insurance. We do have a webinar from Pearl at the end of last year talking about some risk reduction tools and suggestions for you. Please use any and all of this information for your sales meetings. And if you have any other suggestions for upcoming programs this year, please let me know. Thank you, Jay, Bob, Richard, Catherine, Justin. Really appreciate you sharing your time with us this morning.
Thank you.
Thank you, everybody.
Thank you very much.